Hello and welcome to my presentation for health law. My name is Muntaha Arif and today I will be looking into euthanasia and assisted suicide in Canada, specifically the laws in the past, landmark cases, and how they shape those laws to date. For this presentation, I will be focusing on two cases. The first is R v. Latimer, which is a euthanasia case, and an assisted suicide case called Carter v. Canada. But first, let's quickly define what euthanasia exactly is. By definition, euthanasia is a deliberate act undertaken by one individual with the intention of ending the life of another person in order to relieve that person's suffering. An assisted suicide is defined as the act of intentionally killing oneself with the assistance of another who provides the knowledge, the means, or both. Now I will give some background information into the first case. In the case of R v. Latimer, the appellant, Robert Latimer, had a 12-year-old daughter named Tracy who suffered from cerebral palsy. Due to her conditions, she was a quadriplegic, could not communicate, and had the mental capacity of a 4-month-old infant. However, her condition was not fatal, and a feeding tube was believed to help her with her health. Her parents found this to be intrusive and denied it, and after her last surgery in 1993, her father formed a view that her life was not worth living. He then took her into his pickup truck, inserted a hose into the exhaust pipe, and poisoned her with carbon monoxide. This controversial case faced three major issues prior to the court's decision of life imprisonment without parole for 10 years for Mr. Latimer, and they included the court overruling the defense of necessity, jury nullification, and the unfair application of Section 12 of the Canadian Charter of Rights and Freedoms. The first issue was that of defense of necessity. Mr. Latimer and his lawyers argued a defense of necessity, however, the court held that this defense was unjustifiable and inapplicable. The reason for this is because the defense constitutes of three elements that need to exist. The first is the requirement of imminent peril or danger. The second is that the accused must have had no reasonable alternative to the action taken. And lastly, there must be proportionality between the harm inflicted and avoided. In this case, Mr. Latimer did not meet any of the necessary elements, and thus the judge removed the defense. The second issue was that the trial was unfair due to jury nullification. However, the court rejected this argument as they claimed that jury nullification will not be a valid factor in analyzing trial fairness for the accused, and a trial does not become unfair simply because the trial judge weakened the jury's de facto power to nullify. Furthermore, the judge's apparent suggestion that the jury may have some influence in determining the sentence did not call for an unfair trial, because although juries cannot determine sentences, they can make recommendations. The third issue in this case was the argument that the sentence of a minimum of 10 years in prison was long, cruel, and unusual, which made it unconstitutional under Section 12 of the Canadian Charter of Rights and Freedoms. A test of Section 12 demands that considerations be made in reference to the seriousness of the crime. The court noted here that the crime committed by Mr. Latimer led to the most serious of consequences, which was the death of his daughter. At this point, the court took into consideration other factors such as how he had planned the crime, showed no remorse, and how he was distressed over his daughter's condition. The result was that the positive factors did not outweigh the crime, the punishment would also discourage others from taking similar actions, and thus the court rejected the argument. The final decision of the court was lifelong imprisonment for Mr. Latimer without parole for 10 years. It is because of this case and various others that the perception of euthanasia has dramatically evolved. Although Canada is behind a number of countries who permit euthanasia or assisted suicide, we can expect a more positive outcome for those in support of these actions in the near future. The reason euthanasia and assisted suicide may be possible is because of the milestone case known as Carter v. Canada. In summary, the right to assisted suicide in Canada had previously been denied by the Supreme Court in their 1993 ruling, Rodriguez v. British Columbia. In April 2011, the British Columbia Civil Liberties Association, or BCCLA, filed a lawsuit challenging Section 241B of the Criminal Code, which prohibits aiding a person to commit suicide. They claimed it violated Section 7 and 15(1) of the Canadian Charter of Rights and Freedoms. In June 2012, the Supreme Court of British Columbia heard the case and ruled in favor of the BCCLA. However, the federal government appealed the ruling to the Court of Appeal for British Columbia, who in October 2013 overturned the ruling. The BCCLA then filed the case to the Supreme Court of Canada. On February 6, 2015, the Supreme Court of Canada struck down the provision of the Criminal Code and are amending the laws to give Canadian adults the right to assisted suicide on the basis that they meet specific criteria. This law will be in effect in 2016. One of the main issues in this case was that Sections 241 and 14 of the Criminal Code infringed on the basic human rights to life, liberty, and security, which is also Section 7 of the Charter. The right to life is given through laws or state actions which removes death or an increased risk of death on a person either directly or indirectly. The prohibition on euthanasia or assisted suicide deprives some individuals their life as they might be forced to take it prematurely. The rights of liberty and security essentially deal with personal autonomy and quality of life. An individual's response to severe medical condition relates directly to human dignity and autonomy. The prohibition of such acts in this case denies people their right to make decisions that concern their bodily integrity and medical care, which thus neglects their liberty. This has proved to be a landmark case, and the decision that followed is a reflection of our dynamically changing views in medicine. For supporters of euthanasia or assisted suicide, the new laws will give physician-assisted suicide its rightful recognition of a medical service, rather than a crime. Well, that's the end of my presentation. I hope you learned something new today. If you enjoyed hearing about my topic, feel free to respond to these discussion questions.